In this week's episode of the Crushing Debt Podcast, 13 ways to have a successful Chapter 13 bankruptcy.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law. And so I'm just finishing up a 2-day bankruptcy seminar that normally is held locally here in the Tampa Bay area. This year it was on Zoom because of social distancing and COVID, but we're hoping with the vaccine and with all the other improvements to technology that maybe we can have this annual seminar again in person next year. It's the Judge Paskay Annual Bankruptcy Seminar, the ABI, American Bankruptcy Institute Judge Paskay Annual Seminar. And I typically do an episode after every year's ABI seminar, and this year is going to be no different. I do have a second episode in mind that I'm going to record here after I research some of the things that came out of that seminar in terms of either new laws or changes in the laws or changes by the CARES Act or changes due to COVID. So stay tuned for that episode. But this week's episode, what I thought I'd talk about is how to have a successful Chapter 13. Now, admittedly, I file a lot of bankruptcies, Chapter 7s, Chapter 13s, and I do what I can. I do get a lot of my cases confirmed, but frankly, honestly, it takes me a little bit longer than I would like, and probably a little bit longer than the clients would like for me to get their cases confirmed. Now, I don't know that I'm unique in that scenario. I think a lot of the bankruptcy attorneys here in the Tampa Bay area, as great as they are, as great as my competitors are, I think we're all having sort of the same kinds of problems. And I know for a fact that it's starting to annoy our judges and our trustees and our creditors counsel, because the longer it takes to confirm a Chapter 13 bankruptcy plan, the longer it takes for creditors to get paid, the longer it takes for us to get paid as your bankruptcy attorney, the longer it takes for the trustees to get paid, the longer these cases remain on the court's docket. I mean, it's just frustrating all the way around. So I get why, other than our duty of acting diligently on behalf of our clients, the ethical duty to do that, the bankruptcy duty of representing our clients effectively and aggressively and efficiently. There's also all kinds of other great reasons that we need to get these cases confirmed faster. And so one of the sessions that I participated in was with a judge here locally on things that we can do to get these Chapter 13 cases confirmed faster on the second confirmation. Now, before I get into that, I want to give you all a little bit of background about the bankruptcy code. So here's one interesting thing about the bankruptcy code is that the deadline for creditors to file their claims is 90 days. So 90 days after we file the bankruptcy, the creditors have an opportunity to file a claim. And so we say that our client, our debtor client, owes, let's say, Visa $3,000. Well, now Visa has an opportunity to file a claim and say, yeah, that's correct, we're owed $3,000, or that's not correct, we're owed $3,500 or $2,500 or $35,000 or whatever the number is. At that point, then it becomes the attorney's job to send that claim maybe to the client or look at it or something and say, okay, maybe it's right, maybe it's wrong. And so if it's right, do we roll with it? How does that change our plan payments? In other words, if we said the client was owed the creditor was owed $3,000, but they're actually owed $3,500, how does that change our plan numbers? And I would suggest that for that $500 difference, it may not be enough to argue, because over a 60-month plan, if that creditor is getting paid back every penny that they're entitled to, a $50 change is going to be less than $1 change to the monthly Chapter 13 plan payment. So if I said $3,000 and the creditor said $3,500, I may just accept that because it's not worth the dollar per month that it's going to cost to fight over whether that claim is correct. Now, if they say $35,000 and we said $3,000, a $32,000 difference in claim is going to be enough to fight over. And so we fight over the claim, or we don't fight over the claim. And then once all the claims are calculated, the Chapter 13 trustee will confirm that our calculations as the debtor's attorney are correct. And so we've proposed to pay the unsecured creditors X amount of dollars or X percentage of what they're owed or whatever it happens to be. And then that determines if our plan payments are correct. The plan gets confirmed. The trustee, the judge, the debtor, the debtor's attorney, the creditors, we all go to a big hearing, and typically the debtors do not have to attend, but we all go to a big hearing, and that's where the judge says, okay, bangs the gavel and confirms that our bankruptcy plan is correct, and those are the payments going forward, subject to change only in a situation where the debtor's income would go up drastically or down drastically. If it goes up by virtue of submitting tax returns, which I'll get to in a minute, then obviously the payments are going to go up. Now, I don't believe it's dollar for dollar. So if somebody got a $12,000 raise from one year to the next, I don't think that their plan payments are going to go up $1,000 a month, $12,000 divided by 12. But there definitely would be some kind of increase to the Chapter 13 plan in the following year in that scenario. Now, similarly, if someone's income went down $12,000, maybe there's an opportunity for us to reduce the payments. Again, probably not by $1,000 a month, but we can probably file a motion with the court and ask the judge or the trustee to reduce those payments based on the resulting reduction in income. But what I really wanted to talk about today was I brainstormed 13 different ways. Now, I brainstormed them, so some of them may overlap a little bit, but I brainstormed 13 different ways that you can have a successful, meaning confirmed and finished to the very end of your bankruptcy plan, Chapter 13 case. Now, before I get into those 13 ways, I do want to give some love to our sponsor, Sam Cohen, with Attorneys First Insurance. If you're an attorney listening to this podcast, I highly recommend Attorneys First to be your E&O agent, your errors and omissions, your malpractice agent. If you're not an attorney or title company, but you know an attorney or title company, a great way to support me and a great way to support the podcast is to refer that attorney or title company over to Sam and Attorneys First. And the way that you can do that is send them to sam@attorneysfirst.com or www.attorneysfirst.com. What I wanted to do, though, in this podcast is go over the 13 ways that I brainstormed for someone to have a successful Chapter 13 bankruptcy case, meaning the case is filed, the case is confirmed, the payments are made, the debts are discharged. So 13 ways to have a successful Chapter 13 bankruptcy case. So number one, right out of the gate, have all of your documents. Now, I send a checklist of documents to clients that I need as part of my due diligence to prepare their bankruptcy petition. So get me all of those documents. Now, I get it. Sometimes there's an emergency that necessitates the filing be sooner rather than later, or sometimes maybe those documents like tax returns and whatnot may not exist, but get me the documents. Get me all the documents. Now, this applies throughout the entirety of the case. So if I call you at some point, or I email you, or my office sends you an email or gives you a phone call and says, hey, we need XYZ document, send it to us. Don't argue with us. Don't delay. Get us the document. Now, certainly question. I mean, I don't want you to blindly tell you to do what I do. Well, maybe I do, but, I don't mind if you ask me a question, why do you need the document? But don't resist. If I tell you I need a document, it's not because I want to make your life more difficult. It's because I want to make your life easier by getting your Chapter 13 plan confirmed or straightened out or whatever. So certainly ask me why. I'm happy to tell you why we might need a document, but get it to me. Get it to me as quickly as you can. Number two, along with that, one of the great suggestions at the seminar today was contact your creditors before we file the case and get all your payoffs. Now, theoretically, those are documents that we probably might need to submit to the bankruptcy trustee anyway. But typically, what a lot of debtor attorneys do is they'll estimate based on the best information we have. For example, maybe a foreclosure judgment or a statement. A monthly statement or something like that. But if you can get payoff statements, and then the claims vary widely from what those payoff statements say, that may give us an opportunity to even challenge those claims and reduce the amount that you owe potentially. So one of the documents that I really think would be really important and really helpful is payoffs. the payoff on your car loan, the payoff on your home loan. I had a client today ask me about a secured debt against his air conditioning unit. So get me the payoff on that. Rooms to go payoff. Any payoffs. Get us those payoffs, and then we can more accurately reflect what the claims should be, what the claims should come in as. Number 3, your tax returns. Tax returns are, I think, essential. So number 1, it's a requirement under the bankruptcy code. You can't get your confirmation and you can't get your discharge unless your tax returns are current. So get your tax returns filed. Now, that's not to say that, if we file the case in October, November, December, and the trustee wants to see that year's tax returns, well, then they're not due yet. So I think we can push back a little bit there with the bankruptcy trustees, but get us your tax returns. And if you need to file some tax returns, I know some great tax preparers, some CPAs, some enrolled agents. I know some great people that can help you get those tax returns filed so that we can get them to the trustee so that the trustee can evaluate the bankruptcy case. Along the same lines, tax refunds. So here in the Middle District of Florida, here in the Tampa division of the Middle District of Florida, the bankruptcy trustees require that your refund be paid to the bankruptcy court as an add-on. So if you owe $10,000 over the life of your bankruptcy plan and you get a $2,000 refund, that doesn't reduce the amount that you owe to $8,000. That means now you owe $12,000, the $10,000 of that you owed to the creditors initially plus the $2,000 refund. So you owe $12,000 total in my made-up example. Now, there are certain situations where if you've had an unexpected expense, we can ask the trustee to allow you to keep that tax refund. So the air conditioner unit breaks and you need to put a deposit down. The roof leaks, you need to put a deposit down. Your kid needs braces, some other medical procedure, something like that. Let us know before you file the return or while you're waiting for the refund. Let us know that something like that has happened. We can always communicate with the trustee to make sure that we can get their permission, their consent for you to keep your tax refund. So, do that. But again, I'm going to call that 3A because I didn't separately number it. But one way to have a successful Chapter 13, be prepared to either pay your refund into the trustee's office every year or submit something to the trustee's office that some unexpected expense has come up and you'll need to use that refund to pay that unexpected expense. Now, another thing that you can do that I've talked a lot about, if you're getting huge refunds, if you're getting $10,000 refunds, well, you can reduce your withholdings by $500 a month, which would be $6,000 total. So yeah, now you've brought your refund from $10,000 to $4,000, but that does two things. That's less of a refund that we have to argue with the trustee at the end of the year, and that's $500 more you have in your budget to help with your budget, help pay creditors, potentially even put in savings, whatever it happens to be. But, just from a general perspective, not even from a bankruptcy perspective, why would you give the government an interest-free loan when you could have an extra $6,000 in your pocket every year? Again, in my made-up example. But the point here is if you're in a Chapter 13 bankruptcy, be prepared to file your tax returns and be prepared to pay your refund to the trustee or explain to your attorney why you might need to keep your refund. Number 4. Now, this may be a little bit out of someone's control who's in bankruptcy, but number 4 is stability. In terms of stability of home life, stability of work life. Now, I get during a pandemic that may be nearly impossible, but the successful Chapter 13s that I handle all have that issue of stability. The job doesn't really change very much. The income doesn't really change very much. The cases that are more complex to handle, the cases that have a higher failure rate, the debtor is going through 2, 3, 4, 5 jobs, between the time we file and the time we confirm. They keep getting extra jobs, losing a second job, picking up a third job, getting a side hustle, whatever. Once we make that decision to file, try to be as stable as you can. Now, once the case is filed and everything is stable and we're making payments and you want to get some more income, certainly talk to me. Let's figure out the best way to do that. But getting jobs, losing jobs, changing jobs, switching jobs, all that kind of stuff, all that instability makes the Chapter 13 a lot more difficult to confirm. And I know a lot of it is out of the client's control. A lot of it is out of the debtor's control. But again, I think that would be a great way to make the chances of a successful Chapter 13 go up. Number 5, along those sort of same lines, make your payments. We used to have a Chapter 13 trustee here in the Tampa Bay region who retired. His name was Terry Smith. And one thing that he said that always stuck with me, if you want to stay, you got to pay. If you want to stay in Chapter 13, you got to make your monthly payments. Obviously, that should probably be number 1 in terms of how to have a successful Chapter 13 is to make your payments every month. Now, the Chapter 13 trustees do not charge a late charge. So if your payment is due, I'm recording this on the 26th. If your payment is due on the 26th of every month and you decide to pay on the last day of every month, so your payments are going to be anywhere from 2 to 5 days late every month, that's okay. That's not ideal, but it's okay. The trustee's not going to charge you a late charge, and as long as your payments don't go more than 30 days behind, the trustee's not going to seek to dismiss your case. So, to have a payment date on the 26th of the month if you want to pay the 1st of the next month, again, not ideal, but it's okay. You could pay the 15th of the month and pay a few days early. That's okay too. But again, make your payments every single month. Number 6 here. Number 6 in my 13 ways to have a successful Chapter 13 case. Listen to your attorney. I know a lot of you want to be internet lawyers. And again, I really have no problem answering your questions. I have no problem explaining the law to you. But 99 times out of 100, I'm going to know the law better than you. And so if I tell you the Chapter 13 works this way because of XYZ reason, trust me. I mean, if you don't believe me, then I shouldn't be your attorney. You should find another attorney that you can convince that your knowledge of the law is better than his. Now, again, I'm not trying to say that I'm perfect, and I'm not trying to be condescending towards any client. I get it. It's stressful. It's confusing. It's this other language even sometimes that you may not even know. And so, definitely don't, take my word as gospel. I don't mind explaining things to you, but at the end of the day, if I do explain something to you and you go online and read something different, well, is what you read online from the Middle District of Florida? Is it from the Tampa Division? Are the cases in that, the facts in that case similar to the facts in your case? I mean, don't come at me with an argument that a secured creditor made in regards to a car when we're talking about your home. 2 separate assets, 2 separate creditors, 2 separate things. Don't tell me that I'm giving you the wrong advice when you read that your cousin's bankruptcy in Alabama is working different than the bankruptcy that I'm bringing you through here in Tampa. Don't even tell me that if you heard Jacksonville or Tallahassee or Miami, because the bankruptcy is going to work differently, slightly, based on the judge, based on the trustee, based on the creditors, based on your income, based on your assets, based on all those other facts. So again, don't necessarily take what I say as gospel, and I'm really not trying to be condescending here, but I've been doing this long enough that I think I know what I'm doing. And if I tell you something, then take what I'm telling you as correct. I mean, if you want me to verify, if you want me to give you my citations, I'm happy to do that. If you want me to tell you about other clients I've had in Tampa with similar facts, and that's why I'm giving you the advice that I'm giving you, that's fine too. But if I'm telling you something, there's a reason why I'm telling you something, and it's something that we need to talk about, and it's probably something that you need to do eventually. Number 7, cooperate with your creditors. Now, there's a very antagonistic or maybe adversarial relationship between debtors and creditors. Obviously, one is owed money, the other has to pay the money. The one who's owed the money doesn't think they're getting paid fast enough. The one that needs to pay the money says it's too much to pay. So I get the adversarial relationship between debtors and creditors, but a lot of times we need to cooperate with our creditors. If the creditor is challenging our Chapter 13 case, but there's something that we can give the creditor that will show them that we're right and they're wrong, then they'll typically cooperate with us. Or vice versa. If we cannot prove that we're right and they're wrong, maybe the path of least resistance is the best way to go. Now, again, like the point before, I'm not saying you should take abuse from your creditors. That is totally, totally different. What I'm saying is, if you're in an honest dispute with your creditor, maybe cooperation is the better angle to get the case resolved, to get the case confirmed. Maybe settlement is the better angle to get the case resolved, to get the case referred. So again, if you think your creditor is just doing you wrong and is totally wrong, talk to your attorney about it. And if that's true, there are avenues to fight the creditor. But if there's a chance that the creditor may be on the right path, I think cooperation is always going to be preferred over fighting in order to get these Chapter 13 cases confirmed. Cooperate with the trustee. That's my next one, my 8th point here. Cooperate with the trustee. When the case is filed, the trustee will have their meeting of creditors, which I've talked a lot about on the podcast. It's typically referred to as the 341 meeting because it's required by Section 341 of the Bankruptcy Code. But it's basically the trustee's opportunity to ask the debtor questions about what's in the bankruptcy petition. If the trustee asks you to provide backup from a certain thing based on the meeting of creditors, provide it. After that 341 meeting of creditors is over, the trustee typically issues an unfavorable recommendation. Now, some people that know bankruptcy are kind of laughing right now because there is such a thing as a favorable recommendation from the Chapter 13 trustee. Personally, I think those are kind of unicorns and come every once in a while, but maybe doing some of these other things, doing these 13 things here will make favorable recommendations more common and unfavorable recommendations less common. But for now, in my case, I think I've got one favorable recommendation in my 20-something year career here in bankruptcy and foreclosure. So if the trustee puts something in their unfavorable recommendation, all that means is that it's an issue that needs to be cleaned up so that the trustee will support confirmation of the bankruptcy plan, will help the bankruptcy plan to be successful. So if the trustee says they want to see something in the unfavorable recommendation, let's provide it. Let's show it to them. Now, again, there are certain issues that maybe we can challenge the Chapter 13 trustee. If the Chapter 13 trustee is asking for tax returns before the tax returns are due, maybe we can challenge them on that point. If the Chapter 13 trustee is asking for statements on assets that are clearly exempt, if they want to see a deed to a house that you've been using as homestead that you've lived in for 25 years, maybe that's a little bit over the line. But still, if the trustee asks for information, again, the path of least resistance, cooperate with the trustee, get all the information and documentation on the unfavorable recommendation, submit it as early as possible, have all your documents, listen to your attorney. I mean, these 13 ways are starting to overlap with each other, but that's one of the easiest ways to have a successful Chapter 13 case. Cooperate. Now, again, don't cooperate to the point that you're being bullied. Don't cooperate to the point that you're being run over, but cooperate to the point that we can get this Chapter 13 case confirmed. The next thing I have here, number 9, on my 13 ways to have a successful Chapter 13. Be honest with your attorney. Now, we are covered by a duty of confidentiality, so we can't repeat anything that you say, even if it's incorrect or illegal. Now, we can disclose it if we think you're going to commit a criminal act. We can disclose it if we think you're going to commit fraud. But, we can't disclose any information that you give us absent your permission. So be honest with us. I would much rather you tell me an issue and us unpack and resolve the issue before the case is filed than be sitting there with you at the meeting of creditors and have you say, oh yeah, grandma passed away and gave me this, 5-carat diamond ring that's worth $100,000 or whatever. I would much rather know that ahead of time so we can deal with it than learn it when the trustee learns it sitting there at the meeting of creditors. So be honest with me, and then we can diffuse a lot of these potential time bombs before they even happen. So that's number 9 on my list. Be honest with your attorney. Number 10, review the documents that are filed by the creditors and review the documents that are filed by the bankruptcy trustee. Now, again, this goes with some of my earlier points, but you want to make sure that you're reviewing these documents to make sure that they're correct. Do we need to object to any of them? Do we need to challenge any of them? How are they going to impact whether your payments go up or down or left or right? So again, review the documents, be engaged in your bankruptcy case, contact your attorney on a regular basis. Don't call them every day. Don't call them every hour. Don't call them Friday at 4 o'clock in the afternoon and then Monday at 8 o'clock in the morning saying, I've called 2 days in a row. How come you're not returning my call? No, don't do that kind of stuff. But maybe once every month, maybe once every couple of weeks, check in with your attorney and, hey, how are things going? What's going on with my case? Please email me back. Let's schedule a time to talk. Do that kind of stuff. And review the documents and be active in your case. And you can help us get rid of some of these issues, again, before we get to confirmation and before we have to call you on the eve of confirmation and say, hey, this, that, the other issue popped up. What do you want to do about it? So interact with us. Now, again, don't misinterpret. I'm not saying that I'm not going to be active in reviewing your case, whether you do or not. It's my responsibility to review everything that comes in, and I typically do that in all of my cases. Maybe a rare exception here or a bad day there, but for the most part, I'm reviewing everything in all these cases as well. So I'm not saying that it is your responsibility as the client, as the debtor, as the person filing bankruptcy. I'm not saying it's your responsibility to review all the claims and review all these issues, but at the same time, be in communication with us. Work with us. Let's work together to get your Chapter 13 case confirmed. Number 11, estimate properly at the beginning. So again, that's why I want you to provide me with payoff statements. So here's where this point comes in. Let's say that your case, you propose to pay $100 a month. These are not going to be real-world numbers. These numbers are not going to work. But to make the example, let's say you propose a plan that pays $100 a month. And so over a 60-month plan, that's $6,000. $100 a month times 60 months, $60,000. Sorry, I think I got that. I'm doing the math in my head, so whatever it is. Now, let's say that when the plan is confirmed, the trustee says you should have been paying $200 a month, which is $12,000. Now, let's say it takes 10 months to get to confirmation. The bankruptcy code says your plan can only be 60 months in length. Now, there is a COVID issue there that we can possibly extend it for a couple of months if your plan was confirmed prior to a certain date, assuming Congress passes certain laws, assuming President Biden signs them. But in a normal Chapter 13 case, the maximum length is 60 months. And so we propose a plan that pays $100 a month, $6,000 total. Trustee says your payment should have been $200 a month, $12,000 for this or that or the other reason. You've made 10 months worth of payments. So 10 months worth of payments at $100 a month is only $1,000. So now you're required to pay $12 because you were supposed to pay $200 a month, and you've only paid $1,000 because you've been paying $100 a month, and we only have 50 months to complete this plan. So the $12,000 that you should have paid in, minus the $1,000 that you did pay in, divided by the 50 months left in the plan, is $200 a month. So, in other words, we're going to have less time to make the full payment. And I think I got that math wrong. So if you've been paying $100 a month for 10 months, you've been paying $1,000 a month. If you were supposed to pay $200 a month, that's $12,000. So $12,000 minus $1,000 is $11,000. $11,000 divided by 50 months is $220. There, I got the math right. So again, let me back up since I made a math error here. You propose to pay $100 a month. The bankruptcy trustee, after crunching the numbers, and you and your attorney agree that you undershot the numbers and you needed to be paying $200 a month. So you propose to pay $6,000 total to your unsecured creditors. The trustee says it needs to be $12,000 total to your unsecured creditors. You are 10 months into this bankruptcy having paid $100 a month. So you paid $1,000 in. So now you had to pay $12,000. You paid $1,000. You have a balance of $11,000 left to pay what you should be paying to your unsecured creditors. But now you only have 50 months to do it in. $11,000 divided by 50 months is $220. So even though the trustee says your payments should have been $200, that should have been $200 from the beginning. In order to make up that 10 months of a $100 deficit in your payments for the next 50 months need to go up by $20. Now I'm talking about $100 a month, $200 a month. Imagine if these numbers are $500 a month that you proposed and the trustee says it needs to be $800. Or imagine if you proposed $1,000 and the trustee says it needs to be $1,500 a month. The payments could jack way up above your budget because you way undershot what you needed to pay at the beginning. So I think it's a good idea to talk to your attorney about what is your budget and is Chapter 13 even a good idea from the beginning, but understand that the payments could go up even more than maybe what they would have been at the beginning if you undershoot your goals, you undershoot your payments to your creditors here. So again, estimate properly at the beginning, and I apologize for the math error. Number 12 in my 13 ways to have a successful Chapter 13, communicate after the case is over. So bankruptcy is typically 3 years. A Chapter 13 payment plan bankruptcy is typically 3 to 5 years. Most of the ones I do, I think almost every single one I've done, with the exception of a few, has been 5 years. Continue to communicate with your attorney after it's over. Issues may pop up. Did the mortgage company correctly calculate the loan modification? Did they correctly calculate the escrow? Are unsecured creditors who did not file a claim contacting you to get payment from you? You know, there's all these issues that come up. That secured creditor that you thought was secured, were they provided for in the plan? There's all these issues that come up after the case is over. So communicate with your attorney, and if there was some issue that wasn't addressed in the Chapter 13, certainly we can fix it. We can try to fix it depending on what the issue is. Again, this goes back to communicate with your attorney. It goes back to having all your documents. It relates to the other 13 ways, but still communicate with your attorneys after the case is over. And if there's an issue, let's sit down and figure out a way to fix it. My last point here, my number 13 in 13 ways to have a successful Chapter 13, sort of follows number 12, and that's check your credit. Check your credit when the bankruptcy is over. Now, don't check your credit the day you get your discharge. It's going to take some time to filter into your credit score, but check your credit. You get one free pull from the federal government every year, and I think during COVID even more often than that. But check your credit. Make sure that creditors that were included in the bankruptcy show that you owe a zero balance. And maybe after some certain period of time, those creditors fall off and it increases your score. You know, if this was because of a mortgage or a car, make sure that the mortgage company and the car company is properly reflecting your payments, and the fact that you made payments during the 13, and the fact that the loan was modified, was caught up, you know, whatever the situation happens to be there. But check your credit after the Chapter 13 is over. Again, not the day it's over, but maybe give it 30, 60, 90 days and then check it and make sure that everything is correct. You never know. If the credit repair or the credit reporting agencies don't file things correctly when the Chapter 13 is over, you may have the ability to sue under the Fair Credit Reporting Act and get some money and make up some of that money that you were paying in the Chapter 13 because the credit reporting agencies aren't reporting things properly. You know, again, communicate with your attorney after it's over. You may be able to file a debt collection lawsuit against certain creditors if they continue to harass you after the Chapter 13 is over. Again, these are factual analysis, so continue to communicate with us. Continue to communicate with me if I'm your attorney. Continue to communicate with your current attorney. The one last thing that I'll add here, so those are my 13 ways to have a successful Chapter 13 case. Have all your documents. Get the payoffs ahead of time. File your tax returns annually and pay your tax refund to the trustee annually. Have stability in your job situation, your family life situation, whatever it is, to the extent you can, to the extent these things are avoidable. Make your payments every month, number 5. Number 6, listen to your attorney. Number 7, cooperate with creditors. Number 8, cooperate with your trustee. Number 9, be honest with your attorney. Number 10, review documents filed by creditors. Number 11, estimate properly at the beginning. Number 12, communicate with your attorney after it's over. Number 13, check your credit annually. The last thing that I'm going to add here, I file Chapter 13 bankruptcy cases in the Middle District of Florida, Tampa Division. So if you are outside of that area, which is basically in Florida, Hernando County, Polk County, Pasco County, Pinellas, Hillsborough, Sarasota, Manatee. It's those counties. If you're outside of that area, if you're in the Sarasota, Manatee area, if you're in Jacksonville, Duval area, if you're in Miami-Dade, if you're in Leon County, Tallahassee, if you're in Atlanta, Georgia, if you're in Nebraska, if you're in California, if you're in Oregon, check everything that I'm saying with your local bankruptcy attorney, because local rules are going to be different from court to court. State exemptions are going to be different from court to court. The way the trustees work and interact is going to be different court to court. So, double check. Even sometimes the judges are going to be different from judge to judge, because they all have their quirks, the way they like to do things, the way they like to see things presented and argued. So double check with a local attorney if you are listening to the show, but you're outside of the Middle District for the state of Florida. You're outside of the Tampa Division. Double check this all with a local attorney. But I think that'll do it for this week's episode of the podcast. If I missed anything, definitely comment on this show and let me know. If you think I missed a way, if you think, one of these ways is dumb, but there's a better 13th way that we can make these Chapter 13 successful, let me know. If you think there's a 14th, 15th, 16th, whatever way to make these bankruptcy cases go faster, go smoother, be more efficient, definitely let me know. But I think for now, that'll do it for this week's episode of the Crushing Debt Podcast. Like I like to say at the end of every episode, I hope that at the end of the month you have more money, rather than at the end of the money you have more month. That will do it for this week's episode of the Crushing Debt Podcast, and I look forward to talking to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.